Good morning, Miss Furlow. Ma'am, you're charged with terroristic threat.
Hook plus drama woe. Starting off heavy. A terroristic threat charge isn't small potatoes. Even if the word terroristic sounds extreme, legally it often just means making someone fear serious harm. 6 months in jail on the line right out of the gate. This courtroom is heating up fast.
You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. Okay. Officers were dispatched to a residence in Harris County, Texas in response to a disturbance. The complainant stated they were in their car and backing out of their driveway when the defendant parked behind them. The defendant then got out of her car and started banging on the complainant's vehicle while shouting obscenities and threats. The defendant also tried to gain entry into the complainant's vehicle. Specifically, the defendant stated she was going to whoop their ass, and the complainant stated they were in fear for their lives during the incident. The officers discovered the defendant is a coworker of one of the complainant's family members.
Owner, boss.
So the threat is what?
The threat is she was banging on the door and said, "I'll whoop your ass."
I have it on camera.
Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons, okay?
Arrangement plus breakdown. Okay, let's pause. Do you think banging on someone's car while yelling, "I'll whoop your ass," crosses the line into a criminal threat? Or is it just heated trash talk? Drop your take in the comments, because legally, fear for your life is the key factor here.
What do you do for a living, ma'am?
I own a fleet company, 3 trucks, and they're my drivers for the road, my OTR drivers.
Okay.
So they just basically stole my vehicles.
We are going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign and reset. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. When you come back, please have a lawyer, okay?
Okay, but I move out of state next month, so I just talked to my mom.
We'll have you sign and reset, and then we'll just take a seat while we get your bond conditions. We'll have you sign the bond conditions, and then you'll be free to go, okay? Please. You were jail in Washington. Mr. Washington, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent.
Summary plus transition. So Miss Furo's walking out, for now. But with bond conditions in place, one wrong move and she's right back inside. This is a classic example of the justice system giving someone rope. Now let's see if she uses it to climb out or tangle herself.
Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 7th, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it driving with an expired registration as of July 2024 and failing to maintain a single lane, with both left tires crossing over the white marked lanes and the defendant's vehicle failing to signal a lane change. The defendant was the driver of the motor vehicle, and upon contact, the officer observed him with a strong odor of an alcoholic beverage, glossy eyes, swayed balance, slurred speech, and the defendant was slow to answer questions at times. The defendant admitted to drinking, and standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read, and the defendant consented to breath. The results were .106 and .106.
Mr. Washington, I'm going to find that there's probable cause to go forward with the case. How old are you, sir? What do you do for a living?
Currently, I work at FedEx, but I'm in college.
You're currently enrolled in college? Great. Where do you go?
PV. Sorry.
Okay. What are you studying?
Architecture, civil engineering.
Fantastic. Great. It's a big hiccup, man. This can really affect you. You know, anytime you want to get licensed to be an architect, you got to be licensed. All this. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You're not allowed to smoke any marijuana. I'm going to test you. If I find that you continue to use, I'm going to put you in jail. Do you understand? I'm not asking much. I'm just asking to stay clean. That's it. Do you have a Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Sir. But I don't have a vehicle.
Do you see if he has a license? Any prior DWIs as well?
There are no priors, Your Honor. I'll run his license right now.
If you don't have insurance in your name, then you're not allowed to drive any vehicle. You have to have insurance for, I don't care what car you're driving. unless you have insurance on whatever car you're driving, then you may not drive. And don't come up here and tell me, well, the car has insurance. No, people get insured. Do you understand?
Your Honor, he's eligible.
Okay. Did you want to apply for an appointed lawyer? You're going to go hire a lawyer? Okay. If you have any issues, if you want me to appoint your lawyer, just come back, tell me, and I'm happy to do it, you know? I mean, money that you have, I'd rather you spend it on school. Are you sure? You don't want an appointed lawyer?
I'll make a phone call to you. Yes.
Okay. Got to understand that if you're going to hire a lawyer, there's a lot of timing requirements with the DWI. Don't sit and wait a month, 2 months, 3 weeks because you're hurting yourself. You got to do it like lickety split. Do you understand? Okay. Like I said, you ever have any issues, come back, talk to us, and we can appoint your lawyer. Okay. For sure. So I'll have you sign a Risa Victoria. We'll have you get with Felicia for your bond.
Reaction plus legal insight. Yikes. Those test scores don't lie. HGN, walk and turn, one leg stand, he basically failed them all. And that breath test? Over the legal limit. Future architect or not, this guy just built himself a shaky foundation in court.
Conditions. If you have a change of heart, just come back.
Yes.
You know? Okay. Danielle Free. Miss Free, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On November 6, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it speeding 55 miles per hour in a 40 mile per hour zone in the 7800 block of Spencer Highway. Upon contact with the defendant, the officer detected an odor of an alcoholic beverage on the defendant's breath, and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, and one leg stand 3 out of 4. The defendant admitted to drinking and to taking prescription muscle relaxers on occasion. The officer located a case of twisted teas in the defendant's motor vehicle with 2 open cans of twisted teas, 1 in each cup holder. And
Consuming while driving?
There were 2 open cans in the cup holders, yes, Your Honor. And DICs were read and the defendant consented to blood.
Ms. Free, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you not to drive. Do you understand? You are not allowed to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today promising me you're not going to drive. If I find that you do, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I'm also ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you consume alcohol, illegal drugs, unprescribed controlled medication, likewise, you will go to jail. No more PR bonds. Do you understand? Any prior DWIs, Alex?
No, Your Honor.
Any prior criminal history at all?
He has a prior racing on a highway that was dismissed earlier this year.
What do you do for a living, Ms. Free? Why?
I just graduated nursing school, so I was a CNA and caregiver in an independent care facility. But right now I help take care of my great-grandma, so it's just a lot at once.
So how do you support yourself? How do you eat?
I live with my grandparents and I help them take care of her. She can't take care of herself. She has dementia and a mental disorder.
I'll fill out an application for you. I need to know everything about you, how much money you make, what kind of car you drive, any source of income that you have, money in the bank, stocks, bonds, IRAs. I'll have you fill out an application, but I need to know everything about you. Don't just put zeros because I'm going to send it right back to you.
Yes.
Do you understand? And I'll see whether you qualify. Above all else, do not drive. Do you understand? There's no justification that you can give for getting in a car. Likewise, don't consume alcohol or drugs. If you have a problem, you better address it, because if you don't, I'm going to do it for you. Promise you're not going to like the way that I do it.
Yes.
You understand?
Yes.
Okay. Do you mind giving me an application, please? Morning, Mr. Singleton.
Good morning, sir. How are you?
Doing great. You know, it's Thursday, Friday Eve. Ready for the weekend, you know?
Yes, sir.
So,
See, you have the decorations.
thanks. Well, it's all them.
Yes, sir.
Your lawyer has asked for me or is asking for a bond reduction in your case, but, my concern, and I guess my very, very primary concern is public safety. You've got a lot of serious charges, and from what I see, your bond is now at around $200,000. You've got 2 open aggravated assault cases, and you got an assault of a family member with us. Our bond is set at $5,002. What did you guys want?
Possibly looking for a PR bond. Due to the fact that his other 2 cases are extremely high, we believe that he should be able to bond out on that. He has been in talks with some family members regarding possibly coming up with money for the other 2 bonds, but reducing it here would possibly help him out regarding the overall amount that he will have to come up with.
Well, so my concern is, it looks like in September, he had an aggravated assault with a deadly weapon dismissed, right?
I believe that case got filed twice, and they.
So what's going on with the cases upstairs? And is it the same complaining witness as our case?
There's two complaining witnesses on those cases, Judge, and it looks as though it's a different complainant with us.
Is there a weapon involved? Is it a shooting?
On the aggravated assault with deadly weapon, Judge, so in the felony cases, there's 2 weapons involved, a machete and a gun, a 9mm handgun.
Does he shoot at them? Does he
He
shoot?
points at them. So the state would be opposed to lowering bond, Judge, given the severity and the propensity to violence that felony cases also show.
Oh, I think I remember this case. It's about a neighbor, and it's either about like a fence or it's about some bushes or some, right?
So the state's concern is community safety, Judge. So for those reasons, we would be opposed to lowering his bond.
Even if it's not going totally to a PR, is it possible to do 2,500? That was great.
I don't know, I mean, we gave you a PR bond in this case. I let you out, right? And then you go out, you allegedly have these now 2 aggravated assault cases, where in one, you point a gun at someone.
Shoot them in the head.
And if I remember, it's something so trivial over. Don't talk about the cases though, because I don't want you to.
I wouldn't incriminate myself or anything, but I live by truth, sir. And these people stole stuff from me.
No.
But Mr. Singleton,
Not that. Okay.
but there's a certain way when someone takes something from you. There's a certain way that you got to act.
I'm the one
No.
that called the police, Your Honor.
And that may be so, but there's still a certain way to act, right? And if you.
Washington?
Dramatic highlight plus humor 2 open twisted teas in the cup holders. That's not just drinking and driving, that's sipping while steering. No wonder the judge slammed down a driving ban. Honestly, this went from
Refresh my memory, because I just don't remember it.
I can read.
Yeah, go for it. Just a brief synopsis.
On or about September 7th, 2024, complainant Sarver his truck when he was awoken by the defendant knocking on the window with a 9mm handgun. The defendant then pointed the gun at complainant Sarver and demanded that the complainant get out of the car. When complainant Sarver got out of the car, the defendant stated that he would shoot the complainant in the head. Complainant Sarver advised that prior to coming home from work and having his incident with the defendant, the complainant too was also involved in an altercation with the defendant earlier in the night. The second complainant stated that an altercation arose between him and the defendant, which resulted in the defendant punching the second complainant in the face, causing him pain. The second complainant punched the defendant back, and the defendant ran to his house. Shortly after, the defendant returned with a machete in one hand and a stick in the other, and was calling out for the second complainant to come out to the street. So it seems as though he pointed a gun at complainant 1, and then in complainant 2, he punched him, and then When the complainant punched him back, he came back with a machete and a stick.
Sorry, Mr. Singleton, it's just too dangerous for me, man. I can't give you a PR bond. I already gave you a PR bond. We let you out, and then you pick up these two serious cases. You know, if we give you a PR bond now, if we were to lower, I mean, what's going to happen? You're going to pick up a fourth case? We're trying to prevent that from happening, you know?
Order
in the court.
May I speak?
But not about the cases, okay? Just because I don't want you to hurt yourself, you know?
I understand, Your Honor, but I don't recall you ever giving me a PR bond, sir.
We gave you a PR bond on, in our case, we gave it to you on 8/12 of 24. I gave you a PR bond. We let you out of jail. You know, you had certain conditions that you're supposed to follow. No weapons, no contact with the complaining witnesses. And so here we are with two very serious cases. If you're able to bond out, and if you have someone, come back, talk, perhaps we can,
My fiance,
you know, but
the person who this is.
you're your own worst enemy, Mr. Singleton. Really, I mean,
I'm
you're your
sorry.
own worst enemy.
I guess it's the military.
Well, don't blame it on the military. They're choices, right? And
Yes.
sometimes choices are made such that,
I know I need help, Your Honor. I'm not saying I don't need help. However,
the problem is that you can't do that after the fact.
I understand.
You got to recognize it before the fact, before it balloons out of control. That's why, you know, and it's not our first rodeo here with you. You've had prior assaultive cases like this. So you have to understand that when you get these feelings, these urges that you're going to lose, you got to try to take care of this beforehand. Now, why don't we have him T-RAS'd? Okay, let's see what it says. Let's see how to go forward. You know, if they say that there's treatment that's, you know, I have options available to help you with these issues. And I'm willing to help you and I want to. Yeah, we will do it. But the first things first is I got to have you evaluated to see how we go forward. And if you let me do this, and if you're honest with me, Mr. Singleton, let's try to work something.
I will be.
All right. Can you set up a TRAS for Mr. Singleton? Yeah, please. I'm going to set you for an evaluation. I'm going to have you speak to clinicians. Be honest.
I will.
We'll come back in a couple days. Today's what, Thursday? Come back on Tuesday. Let's talk about how we go forward. Okay?
Yeah.
Look, this isn't the be all end all, but let's see how we go forward. You know, that's why God put eyes in the front, so we go forward. We don't go backwards. All right?
Your Honor.
Okay. All right.
Thank you. Appreciate it.
Stay. Okay? You know, Alan, you know, depending on what that TRAS says, it may also help with what upstairs to try to work out some kind of treatment program so that, you know, because it's all just anger, right? Yeah.
That's the first time I've seen her actually. Like that, so it makes
It may be worth exploring because it'll help, you know, hopefully upstairs as well. Yeah, thanks. Yes. Mr. He?
Yes, sir.
Good morning, Mr. He. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Okay.
On November 11th, 2024, officers conducted a traffic stop for a defective license plate lamp in Harris County, Texas. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed a strong odor of an alcoholic beverage, watery bloodshot eyes, and disorientation. Standard field sobriety tests were administered. HGN 4 out of 6. Walk and turn and one leg stand were not administered due to the defendant becoming belligerent. Walk and turn, prior to termination, they had detected 1 of 8 clues. The defendant read the DIC and refused to provide a specimen. A blood search warrant was obtained and executed.
Any prior DWIs?
No, Your Honor.
Okay. Mr. He, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. We will randomly test you. If we find that you consume alcohol or drugs, you will go to jail. And that's it. Do you understand? Do you have a valid Texas driver license? Do you have valid liability insurance in your name? You may continue to drive as long as you have both, and Mr. Murphy will tell you if it does become suspended. If it becomes suspended, you may not drive. Now, because you have a lawyer, we will waive your appearance. You do not need to waste your time coming to court, but you must stay in touch with Mr. Murphy, and he will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're gone and you're not responding, I will issue a warrant for your arrest.
That won't be an issue, Your Honor.
I don't think it will, but we have to put you on notice of what we expect and what, what happens when you start acting up. So we will have you just sign a reset with Victoria. We'll have you get with Felicia for your bond conditions, and then you guys are free to go. Okay?
Judge, thank you
Yes,
very much.
Guys, we're talking about Akin Pelu. Is he on the docket today or no?
No, you just want us to come back.
Let me give you a cause number, guys. And
I remember this case, Judge.
I'm at a loss of everything, You're on 2 different felony probations, both of those for driving while intoxicated. Both of those are felonies. So it's not only do you pick up 1 DWI third, but you pick up a second DWI third. Get on probation for both of those. And now you've picked up here, driving on a suspended license. We ordered you, number 1, not to drive, and number 2, not to consume alcohol. That's all I've ordered you to do. Just don't consume alcohol and don't drive. Has anything happened upstairs?
Well, Your Honor, to be fair, I think the integrity of the machines are in question. 11/7. So when he picked up the first one on 10/29, you told him to test Monday and Thursday.
You picked up what? The machine?
No, when he when you thought it was a tamper on 10/29, he started testing Monday and Thursday, which in this case helps us. So on Thursday, 11/7, he was here in court where he tested. He tested at 12 o'clock. At 11 a.m., it got a tamper and a sign of alcohol. However, he tested clean with the test you told him to take that day. So which tells me that that machine's integrity is not correct. So if the integrity of, and he's maintained that he has not been drinking either time. Every time we did the court, I promise he's not drinking. So if that machine is saying tampering alcohol and he goes and tests on 11/7 at 12 p.m., an hour after the tampering in alcohol, then he may be telling the truth. And I understand what we're dealing with, but he has tampering, sign of alcohol, and then it dissipates and there's nothing there. So
I'm on the same page as you as far as I never want to punish someone who's never done or who has not done anything wrong. That's not, we don't do that. We're the exact opposite. I mean, I scrutinize every single thing that Michael does. Every case, every probable cause, I don't think, I scrutinize the hell out of it. But at the same time, I also do that with people that are in front of us as well as people with charges, right?
And Your Honor, and to say off the record, I know that you do that. I know that you are a judge that will be very fair in these situations. So I'm just saying that. So
he takes a urine sample. It looks like on 11. What day was it?
11/7.
11/7.
I think the sample was taken around noon. He did 2 that day, 1 upstairs and 1 downstairs. So 11 and 1 o'clock. He had to do 2 different samples. 11, I think 07, they say he tampers and a sign of alcohol occurs. So he was here in court, but still have 2 urine analysis around the same time as that he.
Alicia,
Yes,
do you
Judge?
have a test for 11/7? Because I don't have it.
Yeah, so it's probably not in those records because right now just presumptive. It was presumptive, but it's negative. So nothing came back. I have it on my end here. It should be,
What time was